Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments in the realm of domestic taxation. For this, we have selected three important cases. First, where a state cricket board was denied exemption under Section 11 on receipts from BCCI for organising IPL. Second, where a trust was denied exemption under Section 11 and 12 on its entire income, simply because it had earned dividend out of investment in shares. And third, where mismatch in deduction claims unearthed during survey resulted in penal consequences, even though differential amount stood offer to tax. The issue in our first case arises on account of denial of exemption under Section 11 Clause 2 to a state cricket association. The department was of the view that the Indian Premier League matches were highly commercialized events in which huge revenue was generated through TV rights, merchandising and other promotions. The franchisees had been sold to corporate and individuals, and in this process, the assessee had received huge income for IPL subvention from BCCI, service charges and reimbursements. These receipts came to be taxed, holding that they did not come within the ambit of charitable activity.
Let's see what the final outcome of tribunal was. Mere registration of BCCI as a society will not change its nature of being an AOP of the state associations. If the donor, that is BCCI, in its books of account has not treated the payments to state associations as voluntary grants, it is not open to donee to claim the same. Payments by BCCI to state cricket associations having already been taxed at their hands cannot be taxed at the hands of state association, as it will amount to double taxation. If an institution claiming charitable status being constituted for advancement of objects of public utility is barred from involving in any commerce or business, it cannot do so indirectly also by forming a partnership firm or AOP. Commercial exploitation of cricket is not incidental, rather main object of State Cricket Association, and hence hit by first proviso to Section 215, rendering them ineligible for exemption under Section 11.
Now let's move on to our second case, where the assessee trust was denied exemption under Section 11 and 12 of Income Tax Act on the ground that dividend income earned out of investment made in equity shares of Unit Trust of India and 4 other private sector companies is in violation to Section 13(1)(d).
Let's see what the final outcome by the tribunal was. Merely being a chairman in a company does not amount to holding a substantial interest in terms of explanation 3 to Section 13, and hence not in violation to provision of Section 13(2)(h). Even if shareholding is in violation of Section 13, it is only dividend income from such shares which goes out of purview of Section 11 for purpose of exemption.
Now let's move to our last case, where a mismatch in the claim of bad debts in the revised returns with the financial statement filed before the ROC resulted in imposition of penalty under Section 271(1)(c). This penalty came to be levied by observing that although the assessee had paid taxes on the differential amount, however, such disclosure was made only as an outcome of survey probe.
Now let's see what the tribunal has finally decided. It is not illegal to rectify a mistake in return relating to figure of bad debts by filing a revised return if they are not bogus and as per law. Merely because taxpayer has revised his return to declare less income to avoid tax, which is however not supported by any evidence, the department is not authorized to levy penalty under Section 271(1)(c).
With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL for our upcoming episodes. Thank you for watching. Goodbye.